Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
So welcome to another episode of Estates Made Simple. I'm Gordon Vanderleek, a founder and managing lawyer of Vanderleek Law, and here with my co-host, Jenna Carvello of Guardian Estate Company. Welcome, Jenna.
Thank you. Nice to see you.
Likewise. And today is a special episode. While we normally are recording our various conversations on everything estate administration in the normal course, we love it when we have guests, and today we have Melissa Best. So welcome, Melissa, to the podcast, and we look forward to spending a few minutes together to talk where you get to share some of your experience on that. So maybe the place to start might be to give our audience just a little bit of background of your professional career and highlight some of those aspects of your experience that are certainly relevant for executors and administrators of estates in Alberta.
Sure. First of all, thanks so much for having me. I've known Gord for a very long time, and Jenna as well, and they're both respected, knowledgeable members of Calgary's estate community. So Alberta's estate community, in fact. So I'm really happy to be invited to have a chat today. So I'll quickly give you an outline of my background. I was a career money manager for some of Canada's top firms from the time I was a very young practitioner in my late 20s until 2012 when I retired. And back in those early days, I managed money for Royal Trust. And that included managing high net worth portfolios, as well as the portfolios of assets where the trust company was acting as fiduciary, either as an executor, co-executor, trustee, or co-trustee. So suddenly I found myself in the middle of the estate and trust world, and I loved it. And throughout my career in managing money for high net worth individuals and institutional clients, specifically not-for-profits, who are often beneficiaries under estates, I always kept my hand in the estate game. And I thought if I ever retired, I would try to change and disrupt the estate settlement process because it's plagued with inefficiencies, unprofitability, and an enormous amount of frustration often for the families that are impacted by the death of a loved one. So when I retired in 2012, I set about building a software application called Quick Estate. Quick Estate is a two-part digital solution that includes an estate organizer, which is what we're going to focus on today, and an estate executor toolkit, which is the second part of the process once the individual passes away.
Yeah, and what's fascinating about your experience is that from your professional career, that you saw problems or you saw maybe, as you say, inefficiencies or problems to be solved, and then you try to solve them. So I think that's admirable and just shows a little bit of your entrepreneurial spirit or your visionary approach to the practice to say, hey, I'm not just going to observe problems and complain about them at cocktail parties, but I'm actually going to do something about it and create some software, which, having followed your journey along the way, is no small task. But that's not what we're going to get into today. But it's interesting. I think that forms part of your background, and you've been thinking about this for a long time. And yeah, let's talk a little bit on the estate organization, maybe generally, before we get into the specifics of what should executors, or this is applicable actually for all of us, saying, as we're thinking of organizing our estates for a would-be executor, whoever's named in our will, what should we do to help organize that and make their job easier? Or if you're looking at it from the perspective of, hey, I'm an executor, I said yes to my parents and agreed to be the executor, what should I ask them to have ready for me when that time comes so I could be as prepared as I can? With that as by way of a backdrop, Melissa, what do you see as the most common cause of those estate problems from your years of experience and even implementing that software solution, Quick Estate?
That's a very good question, Gord. Most people, i.e. 60% of adults in North America, do not have current wills, which is an astonishing statistic, but It happens to be true, and it's been true for a very long time. And there's all kinds of reasons for that. Nobody wants to face their own mortality. And the second reason may be that they're not sure at that point in their life how their estate should be divided. Their children may not be fully fledged adults, and some might need more help than others. Putting together a will as a start is a daunting task for a lot of people. I would say that a lot of practitioners historically have viewed the will, the accompanying enduring power of attorney, and a personal directive as everything you need for estate planning beyond life insurance if you have children and other financial tools that can help ease the person into retirement as well as ensure there's some assets left for their children. But one thing that gets really overlooked by individuals and by professionals is the whole estate organization piece. And when I built Quick Estate, I started out building the Executor toolkit and quantified all the information that an executor will need to know when the person passes away, and quickly realized that along with that build, I could build an estate organizer. The estate organizer is basically a digital solution that allows people to store important information that their executor is going to need. And before we talk about that, you did ask, what are the common problems? So A, not having a will or not having a current will. And the second I would say is not choosing an executor or executors wisely. Too often in families, people will say, I've got 3 kids and Bobby's very good financially and Susie is very good at organization and Jenny not so much, but I don't want to offend Jenny, so I'm going to name all 3. And often those are not wise choices, or they might name a friend the same age as they are. If they're in their 70s, they might name their friend Bob, who's 75, and he's not going to be available to do the administration likely, or won't want to at his advanced age. So naming the right executor and being careful and thinking about, does this person have basic financial fundamentals? Are they well organized? Do they have the time to do the job? Do they want to do the job? All of those things are super important. And on our website, quickestate.ca, there's a document called Choosing an Executor Wisely, which really lays it all out. And I know that both of you have these conversations with your clients regularly. So beyond not having a will, choosing the wrong people is a problem. The other thing that people often do when they're doing estate planning is they either don't even inform their family member, friend, or whomever they're going to appoint as executor that they've been appointed. So it's often, and I know, Gord, you've seen this many times in your practice, and probably Jenna also, suddenly you wake up and your friend has passed away and you get a phone call saying, oh, did you know, Melissa, that you were named executor? And I think, oh, I had no idea, and I have no idea what's involved. And so that links in nicely to the estate organization piece. So beyond having all of the documents current and well drafted by a qualified estate lawyer, I do stress that, versus a lawyer that does multiple things, get an estate lawyer to do that. Because the estate lawyers, like Gord, have been on the receiving end of estates after someone passed away, where the will was improperly drafted, and that can create all kinds of other problems. Once that's in place, I recommend that you sit down with your executor even before the estate lawyer puts it into a drafted form and say, are you willing to do this? Do you have the time? And if the person is willing, they're going to be doing you probably the biggest favor of your life, because settling an estate is extremely time consuming. And it also involves a tremendous amount of responsibility and legal risk. So by time consuming, I mean that it usually takes an absolute minimum of a year, where it's almost a full-time job to settle someone's estate. If you can do it in a year, you're extremely fortunate. It often goes on for 3, 4, sometimes 5 years to get these estates finalized. So the amount of time, responsibility, and work is enormous. And on the responsibility piece, what people may not realize is that if you are an executor and you make an inadvertent or an ill-informed mistake that costs the beneficiaries money, you can be sued. You're in a position of trustee as an executor, and that means you have what's called fiduciary responsibility. And if you don't follow the terms of what is required of a fiduciary, and if you lose some money, even by mistake, you will be personally liable. So not only is it a time-consuming job and important to the family, but you have to conduct yourself in such a way that you're protecting yourself as well. So that's a quick summary of some of the problems that we've seen throughout the years with estate planning and the gap, which I call estate organization. And when you plug that gap and everybody's well informed, it's a total game changer for the executor, the family, and everybody involved in the estate.
Melissa, I feel like you need your own estate podcast. You are an expert in this field, and we're so happy to have you. But just as your next career path after your next retirement, you could do podcasting. But I'm really curious just hearing you speak about the personal details that are included in the estate organizer that eventually are passed along to the executor. Can you provide our listeners what those details might be?
Absolutely. That's a very good question. So when people think about what are my personal details, they traditionally think about what's my first name, middle name, last name, what's my date of birth, what's my social insurance number, and certainly the executor needs those as well. But for probate, for applying for probate, which is certification of the validity of the will by the court and the ability of the executor to act, you're going to need even more personal details. And Gord would know this like the back of his hand. But beyond your first name and a middle name and last name, the executor needs to understand that the name is written in the will is what's got to be used through the estate planning process. So if my will says Melissa Ann Best, that's what has to be used throughout. If it says Melissa A Best, that's what has to be used. But for probate, you also need all of the middle names. If you have if the deceased had a few middle names, you need all of those. You need to know any previous names. Maybe they changed their name at some point in their life as a result of a marriage or separation. So any previous names need to be known. And also the names of each of your parents and where you were born, for example. So those are just a few of the things under personal details that are important. One other thing comes to mind. Your executor needs to know what your citizenship was and what the citizenship is of your spouse if that spouse is involved in the estate. So that's a quick summary of the personal details that the executor needs to know.
And so that's really helpful to have in advance too, so the executor doesn't have to go searching through all these old documents and collect all these specific details to apply for probate, which is why your estate organizer is so helpful.
Yeah, and on that, what about getting into the specifics of, or I guess while on contact information, another issue is who are the beneficiaries and what information do we need from there? That's often helpful to have. Maybe speak to that a little bit and collecting that information.
Sure. The proper names of the beneficiaries, as stated in the will, are important. Their ages are important. Their social insurance numbers are important, as well as how do you reach them? Is it email? Is it phone numbers, et cetera, et cetera? But beyond the executors and the beneficiaries, there's other people involved. When we collect data, we also collect information on who is the agent under an enduring power of attorney, who is the agent under a personal directive, because the executor may find themselves in a situation with an elderly parent who's not going to last a long time, and they may need to activate the enduring power of attorney, for example. If I go down the list top to bottom, it's emergency contacts, it's the agent under an enduring power of attorney and a personal directive, and then it's the executor, the beneficiaries. If there's minor children or disabled dependents, which Gord knows a ton about, you also need to know who the guardians of those people are going to be if you pass away. And then we get into the realm of professional advisors Who's your accountant? Who's your lawyer? Who's your banker? Who's your investment advisor? Who's your life insurance professional? So all of those professionals contact a list of who they are and their role in your financial life and how to get in touch with them should be included as well. And then there's a host of other service providers. We all have people that do things for us and companies that we rely on, like utilities companies, your internet provider, your cell phone provider, your physician, for example, and other people like your cleaning lady, the guy that maybe cuts your grass, the guy that shovels your snow, and of course, family members, friends, and neighbors who may not be mentioned in the will, but all need to be notified.
That's actually a really good point. I guess while we're wrapping up the people part of the organizer, it almost seems, right? A couple things to comment on there. Number one, I know through the new surrogate digital system, it's all goes by email. There's a real practical, just having those beneficiaries' email addresses would be important, or the contacts. A second comment would be in some cases, if you have these lifetime trusts or you have trusts with remainderment beneficiary, or there's people who have contingent interests in the estate, those have to be disclosed and highlighted through the probate process. So they're almost seemingly removed. What business do they have? They're not getting a gift, but they need to be notified that there's a trust of which they get the remainder of. And that means in circumstances, the probate process requires that they get notice of that contingent interest. Obviously, a lawyer will be involved to help identify who has to receive notice. But to the extent the organizer can gather all that information, just thinking it through as a practitioner, just want to comment on the utility of this, because if somebody calls and says, I want a first appointment, somebody's passed away and I'm the executor and I want to bring in the will, can I talk to you, Gord? Guess what I'm doing? I'm sending him an email in advance of, here's all the things I need from you, either at the first meeting or shortly thereafter. And to the extent is, print estate organizer, and it's all there. Oh, goodness, that would save a ton of time, because I know on a very practical basis, I give that homework to people before a first meeting, and they are spending a lot of time getting prepared for that meeting with me. So just looking at it from that perspective, for the prospective executor, you know that this is going to be a list of homework. So the more you can have that organized, or get the person who you said yes to organize it in a digital tool, and this is where this is so lovely, just makes even that first step in the whole process, once you get beyond kind of the dealing with the funeral, so valuable with that. So just, I guess, some commentary on that, not particularly a question. But let's move a little bit to some of maybe the property issues. In your organizer, how do you break down our assets? Because there's a whole variety of different type of assets. So could you give our listeners a sense of what sorts of things should they be identifying as part of getting everything organized in their estate?
That is the meat and potatoes, frankly, of our software, because an executor's most important job is proper stewardship of the money. And that starts with finding out what the person owns, what they owed, and where everything can be found. So this is super, super important. Our software covers 42 different types of assets. And that sounds like a huge number, but if you think about it, under the category, for example, of financial assets, you have the obvious: bank accounts, investment accounts, life insurance policies, other types of insurance. Who's the car insurance? Who's the home insurance provider? Is there life insurance? Is there critical illness insurance ahead of death, etc.? The income sources of the person who's passed away. That may include employment income. It could include private company income, etc. And further to that, do they have any interest in private companies? Maybe the person's parents recently predeceased them, and they still have an outstanding interest in the estate of a parent or a trust of the parent. Where's the safety deposit box? Where's the key? Are there any loans outstanding to the person that passed away? Maybe the person lent money to a friend and they've got a promissory note and they're owed $10,000, something like that. That's an asset of the estate, collecting that money. So that's just a few examples of financial assets. And I should mention that I would put agricultural assets that are productive under that category as well. And that's a whole other story, because the person that died may not even be managing the farm assets. It could be somebody else. So that's important. And further to land, let's talk about real estate. You have a principal residence, recreational properties, whether they're a lake property in Canada or a nice little condo in the desert in the US, which requires special handling because of tax rules. And then, of course, commercial real estates. Maybe you're an owner of a building where you have your private company. And then there are benefit plans that are provided by the government, and benefit plans that may be associated with your employer or a private company where you're one of the partners. The other general category is personal use assets, and this includes paintings, wine collection, jewelry, any other forms of art. You may have a collection of war medals. You may have and other assets that don't fall into those categories. Maybe you have some mineral rights. Maybe you have some royalty income. So everything you own, everything you owe, and everything you earned has to be listed, including the provider, where the account is, and how to reach them. So that's really important. One other category of assets that we're dealing with much more these days is digital assets. Where are your passwords? Are you using a password vault, an online password vault, where your passwords for all your digital applications are stored? I don't recommend storing the passwords for your financial accounts with anybody, regardless of how secure these vaults have become. I think that's something you take great care with, and call me old-fashioned, but I like to have mine written down and updated periodically in a secure location so that nobody can break into my bank account or my investment accounts. So digital assets are a big deal, and if the executor either doesn't have the master password to get into a commercial digital vault or any of the other passwords, it can create a lot of issues because a lot of digital providers are very focused on privacy and they won't let you in. Fortunately, as Gord would know, the law is changing such that executors these days, if they need access to a digital asset in order to settle the estate, and if the digital provider isn't being helpful, they can make a court application and that provider could be forced to provide access. So needless to say, the asset piece is going back to my initial comment that managing the money is the most important job of an executor, because if you fail there, you've got beneficiaries suing you and the litigation pipeline opens and it's a disaster. One other thing that I didn't mention earlier is that it's also important not only to know what you own, what you owe, where is it, who needs to be called, but where your legal documents are. And executors cannot deal with copies of legal documents. They need the originals. So this includes wills, all the other estate documents, but it also includes things like if you're in a business, a shareholders agreement, partnership agreement, buy-sell agreements, and even your personal documents, like where's your passport, where's your driver's license, and all your income tax information. Where can all of that be found? Because your executor is going to need to get their hands on all of this. And if you're organized, not only does it save the executor an enormous amount of time, but you're also going to save money on legal fees, because when you go to see Gord, you've got everything he needs ahead of time. Or if you're going to your accountant, you've got everything they need. And on our website, quickestate.ca, at the bottom, there's a little article called Executors Before You Go to a Lawyer. And there's no point in calling Gord until you have all this information, because he's going to ask you for it.
That is just wonderful tips. I echo Jenna's comment saying you're a podcaster in the making here. You could go on and on for that. So I support that motion. And I think it's really helpful to identify that we've got the different categories, and everybody's situation is different, but you want to sit down and say, what of that applies to me and what do I need to organize? But really the related documents. I'm glad you finished your last comments with regard to that, because oftentimes, selfishly as the lawyer, I need those documents in order to give legal advice to the executor. Is there a co-ownership agreement for that property in Vermeer? I need the title documents. Was it joint? Was it not? I got to first figure out what's actually in the estate, what's outside the estate, and answer all these questions. So I need the documents to be able to render a legal opinion as to what's going on with this. The other thing that is helpful to know is also jointly held assets. Because actually, through the surrogate digital process, you have to disclose those assets that were in joint names and take a position. Is it part of the estate? Is it not part of the estate? And there's usually a lot of fighting about that when there's a lack of documentation. So the fact that we're thinking about a deceased person in their lifetime, they could say, here's the documentation. Is there a deed of gift? Where is it? Or what was intended with regard to this property? And just putting your mind to that and listing all those things would be really important. It can make a fundamental difference on the estate. And quite frankly, if there's a lack of clarity on those issues, the intent goes with the deceased person, because that knowledge and the lack of documentation is only to be guessed as to what did mom and dad intend with regard to this asset. So that the estate organizer is going to force that issue to say, we want to document all that, and can really, so I can see a saving of cost, because if you're reducing the number of hours the executor is going to bill, if they're looking at the quantum of hours, there's a real practical benefit of this work in advance, because you're going to save executor fees, which means more for your beneficiaries, the less legal time having to scramble around and deal with all these problems, and just less stress. I'm sure in your many years of experience, you've also seen conflict about some of this stuff. And I know that that's also a bit of your passion in terms of trying to solve that problem. I don't know if you want to speak a little bit to that as we wrap up here about how these sort of tools can help reduce conflict or the risk of that conflict within families.
That's a good question, Gord. And I should mention quickly, good point that you made about joint ownership, because there's two types. There's joint ownership with right of survivorship, and there's joint tenancy, which means Gord owns 50%, 40% of the building, and I own 60%. And if Gord dies, his executor has to collect on his share. In our software, for every single asset that could be joint owned or every single debt that could be joint owed, we have a segment where you can specify what type of ownership it is and what each person owes, because that can solve a multitude of problems. Just going back to your other question about time saving and whatnot, this whole piece of estate planning has been woefully overlooked, the estate organization piece. And I think most responsible providers, I'm sure the two of you suggest when you do up documents, or if you're finding the right fit, Jenna, for a client in terms of available professional executors, you probably said in passing that this should happen, but I don't think people realize how big a difference this makes in terms of turning the executor into an informed decision maker. And in our executor toolkit, which is what people use after the individual has passed away, we have a tremendous amount of content, because most people have no idea what this job entails. And it's not common knowledge how you have to manage a lot of this stuff. And you're under the legal umbrella as a fiduciary, so you have to know how to act. So the goal of our estate executor software is to turn the executor into an informed decision maker. And the software offers templates and forms and all kinds of tools to make the administration after death much more efficient. In short, our goal is to make Edning's job faster, easier, and cheaper. And if they're organized and well-informed, it will reduce the risk of family conflict. It will reduce professional advisor fees, such as legal, accounting, and it also protects the executor against lawsuits.
I think that's a great point, Melissa. And one thing that comes to mind is the fact that you are disrupting the estate settlement and planning market. We've seen other companies in this space as well disrupt the market. So I'm curious of what other options are available to our listeners if they are looking to plan and settle estates.
That's a good question. And I should say that our software at this point, Quick Estate, and you can go to quickestate.ca to see what it looks like and what we offer. At this point, it is only available through professional advisors, including people like yourselves, accountants, financial advisors. Eventually we will probably make it available to the general public, but I really feel that a key person in this process is the professional advisor, because if they know what's going on and what the person owns and the circumstances of their family, they can render a lot better advice, whether it's drafting documents, providing life insurance, investment advice, etc. But if you are not dealing, unfortunately, with a financial advisor, lawyer, accountant who uses Quick Estate, there's nothing better than just pad and paper. Create a file, make a note of all this stuff. Who needs to be called? Where are your documents? What do you own? What do you owe? And where is it? And what are all your personal details? As long as you update it once every year or two to make sure the information is still current, or if you're a bit of a spreadsheet nerd like myself, do a spreadsheet or do it in a Word document on your computer where you can quickly go in and take a look at it and say, yep, most of this stuff is pretty current, because a lot of it doesn't change that frequently. But if you can print something off or hand a neat typewritten or handwritten file even to your executor and say, here it is. Thank you for doing this. I'm trying to make your job easier. It's a total game changer. And for people that like to keep their affairs confidential in terms of the value of their assets, they don't need the dollar amounts. All they need is to know you have an account at Bank of Montreal or at MD Management or wherever it is. And this is the nature of the account. Is it an RSP? Is it a investment account? Is it a checking account, et cetera? And which branch it's located. That in itself is a game changer. The executor in the organization process does not need to see the market values of anything.
And it doesn't need to be complicated. A notepad is a simple way to relay information that otherwise, exactly what you're holding up right now, that
And
otherwise would be unknown.
Yeah, that's all you have to do. And I just think it's really sad that the professional community, over all these years that I've been in business, 40 years, has never insisted on this. So beyond creating that executor toolkit, it was a real aha moment for me to create the estate organizer, which some would argue is even more important than the executor toolkit.
Yeah.
Thank you so much, Melissa. We appreciate you coming on and sharing your story and your insights and recommendations to our listeners. I think you may have earned another client in Gord in his office, so you'll have to hit him out after. But it's been an absolute pleasure learning from you and hearing from you, and we thank you for joining us today.
Thank you so much. And I came today because I really appreciate and respect all of you as such active participants in our estate community. I know that you're doing a very good job for your clients. And thank you for the opportunity.